Welcome to The Explainer. Today, we're getting into one of the most significant Supreme Court rulings in modern American history, Dobbs v. Jackson Women's Health Organization. Yep, the decision that overturned Roe v. Wade.
So let's just jump right to the punchline. This is the final holding, taken straight from the decision's syllabus. This single sentence, right here, it reversed nearly 50 years of precedent and completely redrew the legal map of the United States.
So, how in the world did the court get to that conclusion? Well, we're going to break it down into four key parts. First, we'll look at the reversal itself and the state law that got this whole thing started. Then, the big one, the epic clash over how to read the Constitution. After that, we'll dive into the debate over stare decisis, the power of precedent. And finally, we'll look at what comes next, because this decision opened up a whole new can of worms.
So, where did this all start? It wasn't some big federal action. No, this whole thing began with a single law passed in the state of Mississippi that brought this monumental question right to the Supreme Court's doorstep.
Okay, so the case was all about Mississippi's Gestational Age Act. By banning abortions after 15 weeks, it created a direct conflict with that long-standing viability line from Roe and Casey, which was around 24 weeks. And look, this was not a subtle move. The Mississippi legislature very intentionally built its case, including its own findings on fetal development and even calling a common abortion procedure barbaric. This was the challenge that many states had been waiting for, and sure enough, 26 other states jumped in, basically telling the court, use this case, it's time to end the Roe era for good.
Now we get to the core constitutional fight. And you have to understand, this wasn't just about abortion. It was really about a fundamental disagreement on how to read the Constitution itself. Specifically, that one little word, liberty, in the 14th Amendment.
And this right here, this really gets to the heart of it all. The whole conflict boils down to these two competing ideas. On one side, you have the majority asking, was a right to abortion deeply rooted in our nation's history way back in 1868 when the 14th Amendment was passed? On the other side, you have the dissent asking a totally different question. Shouldn't a document with big, broad principles like liberty be able to evolve with our society?
So the majority opinion, written by Justice Alito, went all in on this strict historical test. Their argument was, basically, for a right to be protected, you have to be able to find it in the nation's history and traditions. And when they looked back, they found the exact opposite. They pointed out that in 1868, 28 out of 37 states actually had laws making abortion a crime. So from their point of view, Roe didn't find a historical right, it created one out of thin air, based on what they called an erroneous reading of history.
But the dissent came back with a powerful counterargument. They said, hang on a second. This whole historical test is deeply flawed. Their point was that looking to 1868 is a huge problem because, as they wrote, the men who ratified the 14th Amendment did not perceive women as equals. So, the dissent argued if you use their limited perspective, you're basically freezing a 19th century view of women's rights into our Constitution forever.
And this is exactly why the dissent believes the framers used big, broad words like liberty. The idea was that these principles could be adapted over time. For them, interpreting the Constitution isn't about digging up specific practices from 1868. It's about applying these timeless principles to the world we live in today, with our modern understanding of equality.
This huge constitutional disagreement leads right into the next major hurdle for the majority. They had to explain why it was okay to just throw out a precedent that had been the law of the land for half a century. And that brings us to this core legal idea called stare decisis. It's a fancy Latin phrase, but all it really means is to stand by things decided. It's the whole doctrine that courts should stick with their prior rulings. And it's not just about tradition. It's what makes our legal system stable and predictable. It's a pretty big deal.
The majority tackled this head-on. They basically said, look, stare decisis is not a straitjacket, especially when we're talking about the Constitution. In their view, Roe wasn't just a little bit wrong, it was egregiously wrong with exceptionally weak reasoning. And for them, when the court makes a mistake that profound, it has a duty to fix it, no matter how long that mistake has been on the books.
A huge piece of their argument was aimed at the more recent Casey decision and its undue burden test. They argued it was just plain unworkable. I mean, what is a substantial obstacle? What counts as a large fraction of women? The majority said these terms were so vague that they just created a mess, a patchwork of conflicting rulings all over the country, and confusion even among the justices themselves. The dissent, though, saw it completely differently. They were like, wait a minute, working with flexible standards is what judges do all the time.
They compared it to the kinds of tests used in free speech or antitrust cases. They called it a known, workable, and predictable standard, arguing that applying general rules to specific situations is, well, pretty much the definition of a judge's job.
So, overturning Roe didn't actually end the legal debate. Not even close. In many ways, it just kicked off a new, way more complicated chapter, raising all sorts of profound questions about what happens next.
In his separate opinion, Justice Kavanaugh was very careful to frame this decision not as a ban, but as the court becoming neutral. He argued that the Constitution just doesn't say anything about abortion, so the court's proper role is to get out of the way and let the democratic process, state legislatures and Congress, figure it out.
However, and this is a big however, Justice Thomas, in his own concurrence, took a much, much broader view. He basically said that the same legal reasoning used to overturn Roe, that a right isn't protected unless it's deeply rooted in history, should be used to re-examine a bunch of other landmark cases. And he named names, the cases that gave us the right to contraception, same-sex relationships, and same-sex marriage.
And that is exactly what the dissent was warning about. They argued that the majority's historical test logically threatens any right that isn't spelled out word for word in the Constitution. They ended with this really stark warning, suggesting that the Dobbs decision wasn't an endpoint at all, but maybe just the beginning of a whole new wave of challenges to our personal freedoms.
So, at the end of the day, while the court answered one massive question, its decision blew the doors wide open to a dozen more. I mean, what new constitutional questions will come up now? We're already seeing legal battles over whether a state can stop its residents from traveling to another state for an abortion, or if they can block abortion pills from being sent through the mail. These fights pit state power against fundamental rights, and they guarantee that even though the era of Roe is over, the legal and political battles over abortion in America are far from finished.